Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altishan, Director of Client Partnerships here at Pacific Cascade Legal. And today we're here with our bankruptcy attorney, Darin Wisehart, to talk about what you need to know about the meeting of creditors in a bankruptcy case. Hey, Darin, how you doing today?
I'm doing great. Thanks for having me today.
Oh, thanks for being on. So, Darin, yeah, I imagine that it can sound pretty scary to a person who's looking to file a bankruptcy. I have to sit down and meet my creditors who I'm about to stop paying. I think my first question would probably be, do I really need to attend the meeting?
And the answer to that is yes. The answer to that is yes. So you will have to do a meeting. What happens there with the meeting of creditors? It's the meeting that's scheduled the day you file the case, and that it'll be scheduled about 30 days after you file your case. And that allows the creditors and the trustee to oversee the case a little bit, to see, if the documents are true or accurate, and that's what they're checking for. And basically gives them a chance to ask you questions if they want to. And that's what bankruptcy is all about. Bankruptcy is all about getting the opportunity as a creditor to ask questions and make sure that you're following the rules. Are you doing everything that you're supposed to? Now, the beauty of that is your attorney will have you prepared. So for the most part, you'll go into that knowing how it's going to go and how it's going to play out. And we want to make sure we take away this unknown aspect of it that most clients have that creates stress. We want to take that out of the equation so that when you go in to the meeting of creditors, you're ready for it. You don't have that additional unknown in your mind.
Oh, I like that. The less unknowns, the better. So is this going to be in a courthouse? Is it at a judge's place? I mean, where is it held?
Pre-COVID, it would have been in a building in a downtown area around where you're at in the United States, all across the United States. Most of the big cities, they house them in a lot of different locations in relation to where the people are going to go to the hearing, and that's how they've always done it. Post-COVID, once COVID started, we had a major positive from that, and that allowed trustees then to do those hearings on the phone and at times with video, so that you could do them from anywhere. You could do them from your front room and have that comfort of knowing that you don't have to go into the old 1960s room with the really bad lighting. Now you can do that in the comfort of your house. A lot of times for clients here in Oregon, what I try to do is I try to bring you into the office so that you're sitting across the desk from me, and we can put my phone on speakerphone and we can do the hearing together where they can't see us, but at the same time we have some communication that we can have, and it gives the client comfort of knowing that I'm sitting right there listening to everything and really just making sure that we're protecting the interests of the client and making sure that the hearing goes the way that it should. So most of the time now it's on the telephone, and that allows us to be really flexible with how we schedule it and how we make it work.
I think you mentioned that it gets scheduled shortly after you file. So kind of a couple questions I kind of would have would be like, how do I prepare for it? How far off is it going to be? And, how long is it going to take?
A couple of really good questions. So the big one on how to prepare for it is, if you tell the truth in your documents and you review them before you sign them, before your attorney files them, then you've done relatively everything you need to do for the hearing. Okay, so the beauty of this hearing is if you go through those doors or you get on the phone and your goal is to tell the truth, which is something I counsel every client to do. It's a no-brainer in bankruptcy. If you're telling the truth, it will set you free. It's the path to not having to remember anything. You can do the hearing in your sleep if you're telling the truth, because these are facts and pieces of information that you have in your quiver, but well before you go into the thing. And if you've filed and signed correct documents and they're all accurate, that's part of what the trustee is doing, is making sure that your documents are accurate. Is the material reflective of the truth? And maybe there's some bank accounts. One of the questions they ask that's very common, do you have any other bank accounts other than this bank account and that bank account, the ones that are listed in your documents? And so that allows the trustee to then double check to make sure that you don't have things that might not be listed in there. Sometimes clients accidentally omit things, and that gives us a chance to check those documents.
I'm guessing I'm not really allowed to plead the fifth.
Well, you're allowed, yes, but they can continue to ask the question. I mean, it doesn't really come into play all that much in bankruptcy, because in bankruptcy is a shine the light on the process. And when you file documents, you're under oath. So you've got to tell the truth. And now you have to work your way through making sure that these documents are reflective of everything that's true in your estate, which is all of your assets, all of the things that you own, things like that. And that's what the documents are all about. So when you sign those, you're signing them just like you sign your taxes every year. You're signing them under oath and that they're true. And when you go to the hearing, you're reasonably supposed to be saying the same stuff. If you're not, then your documents should be different. So there's no element of pleading the fifth, but obviously if you're down that direction, then you need to make sure that's discussed at length with your attorney.
I like it. So you talked about answering questions and talking. Who am I answering questions from? I mean, who runs the meeting of creditors?
The day you get filed, you will schedule that, and you will be assigned a trustee. And the trustee it sounds like a very scary position. Oh, the trustee, I don't know who the trustee is. The trustee is in Oregon. We have extremely professional, very good trustees. They're all the way across the board, and across the United States, most trustees are very good. They're very professional. They're very straightforward. They're looking for the facts. Give me the facts, and that's what they're looking to get. And that person is the overseer of the case. And their job is to make sure that your schedules, your documents are all where they should be. They have all the information in them, and that you're telling the truth on everything. And if there is anything then to liquidate or sell, or anything that is going to go to the creditors, then it's their job to collect it, sell it, do whatever needs to happen. Of course, you're going to talk with your attorney about that to see if that is in your case. But it's their job then to distribute that out to the creditors by the way that the statute says. So they're kind of that overseeing referee that is not on your side. Their job is to protect all of the interests, creditor and individuals, and sort of see a middle ground, but also make sure that they're doing everything by the law that they're supposed to do. So they're kind of a referee in the case that makes sure that everything happens the way that it's supposed to happen. And they conduct that hearing. They ask all the questions. For the most part, they ask the same questions for every hearing, with a little deviation depending on what's specific to your case. And that's the person that will conduct it. They're not all the people that will show up. Sometimes you have creditors. It is called the meeting of creditors. And when they show up, you have the same type of, they'll ask you questions. You have to tell the truth, all of that type of thing. But usually, if a creditor is going to show up, you'll have a heads up on when that's going to happen. 9 times out of 10 for the hearings, it really is just the trustee, the individual, and the individual's attorney. And that's really the people that are on the horn for the meeting of the creditors.
Got it. So it's just people asking me questions, and it sounds like it's something I can get through. So is the trustee like a judge? I mean, can they legally tell me I have to do something, or do I have to even answer these questions under oath there?
You have to answer them under oath. If you don't answer them under oath, then you're going to get an additional examination, and that's going to be further work for everybody. The easiest way is to answer the questions under oath. The trustee is not a judge. I do have, every once in a while, have a client finish their statement with "Yes, Your Honor," and they're not a Your Honor, even though they're an honorable position. They're not. You don't have to address them as Your Honor, but they are a person that's just assigned to a case. Their job is, to oversee the case, to be that middle person, so that the judge doesn't have to get their hands dirty on the case, except for if there's a dispute. And there are situations where a trustee will ask a question or a line of questions, and the attorney will step in and say, we don't choose to answer those, or we're gonna, sometimes there are some situations where you don't answer questions for the trustee, and sometimes you have to go to the judge and say, go to the court and ask them if you need to answer these questions, or if you need to submit documents, or or do things like that. I mean, it's the trustee's job to pour into these things sometimes, and every once in a while they pour in a little deeper than they should. So it's sometimes necessary to go before the judge if you have a dispute. They're not the end of the trustee is not the end all be all. That's the judge, and if then the appeals court after that if it ends up going a way that you don't think it should. But they are just an individual that are very professional. They're very good at doing what they do, and their job is to just get everything in line and make sure everything's happening the way that the statutes, the laws say that it should be working.
So let's talk just a little bit about kind of what happens when you're at the meeting of creditors. Do I need to prove who I am? I mean, are there questions that I know I'm going to get asked, so I better be ready for?
Yes to both of those. So you have identification requirements to make sure that you're you and that you're filing the case for the person that it says on the documents. And the trustee always wants to validate those pieces of information. Driver's license does the job real well for ID, for picture identification. And usually a social security card will confirm the social security number matches the person, so that, you know, that's the first part of every hearing, is to make sure that those pieces of information are in line so that we're dealing with the person we're supposed to be dealing with. And sometimes it's a little trickier on the phone because, you know, they are on the phone, they're not in the room with them. So, you know, sometimes it can be a little bit tricky, but your attorney will have all that ironed for you. And that's something you don't have to worry about if you've hired an attorney that is good. Those are things that you can take off your shoulders and say the attorney will handle those types of things. As far as questions, they ask relatively the same questions every hearing. They will have some deviation, and it depends on what type of case you have, Chapter 7 or Chapter 13. The Chapter 7, you know, once you get to a certain spot, they're really just asking questions to follow up on information that they've seen in the documents and making sure that everything is listed properly and everything is where it needs to be. And in a 13, they might delve in more on your budget. They might delve more in on what assets you have and how you value them, things like that. It tends to be a little bit different. But the beauty of hiring a good office, a good attorney that does this for a living, is that they will have, I mean, not necessarily the script, but you'll have a really good idea what questions you're going to see when you get into the hearing, and you'll be prepared. I tell every client, if you stress 1 minute about that hearing, when we get done, you're going to look at me and you're going to say, Darin, I don't know why I stressed about that. It's not that big a deal. It was just that unknown factor that was stressing me.
Oh, well, that's a good thing. It's back again really kind of quickly to the creditors themselves. You said they normally don't come, but they might. Should I be prepared for what kind of question is a creditor going to ask that, you know, maybe the trustee wouldn't or already would?
Yeah, the creditors, so when they show up, usually they're asking, obviously they're always going to ask about their credit card or about the car that you have, that they have liened. These are the types of questions that they want to know. When did you get it? What did you intend when you bought it? Did you falsify a document? Maybe did you put a lot of money on a credit card within a year of filing the case? These are the types of questions that they might want to know, because these are the things that they might be able to tie to you so that they go through the discharge. They don't get discharged when the case finishes. And that's usually what they're getting at, is they're trying to get that extra information. And that's why they don't show up very often, because these things don't happen very often. The beauty of that is, though, as you get into the pre-file stage of your case with your attorney, they're going to ask you all of these questions. And if you're making sure that you focus on telling the truth and focus on giving your attorney information so that your attorney can kind of go through what are the chances of something happening, that's going to stave off any worry with this hearing. Because the last thing any attorney that does this for a living wants is to get into that hearing and have somebody show up that they did not expect. You don't want unexpecteds in my business. You want to know exactly where you're going. And the best way that the client, that the individual can help, is by giving all the information. When there's a question asked in a packet or from a staff member, you answer it completely. And every once in a while you go, well, I don't know if it comes in, but let me tell you about this. Okay. And then the attorney can cut you off sometimes, to say, okay, we don't need any of that. That's okay. That doesn't play in. Or, hey, wait a second. We need to chat about that, trip to Europe that you put on your American Express card 3 months ago that was $7,000. And now you're filing bankruptcy. We need to chat about that because that can be a very real issue in a meeting of creditors.
Got it. Wow. Well, we just blasted through the time. And once again, Darin, thank you. Meeting of creditors sounds scary as heck. And I like the way you talk about that, it doesn't have to be, especially with a good attorney. So thanks so much for joining us today.
Yeah, no problem. And the takeaway really is it's not a scary event. It's a straightforward, get the facts and move forward. And that's how everybody wants to look at it. And if you're prepared, if you've hired a good attorney, you're going to be ready for that hearing.
I love it. Well, thanks again. And thanks everybody for joining us today. Anyone has any further questions on today's topic, you can post it here. We'll get you connected with Darin. And until next time, stay safe, stay